Welcome to the DIFC DRA Academy of Law. In keeping with our mission of providing local legal education with global value, the Academy is delighted to host Lecture Series number 3 of 2016. I am honored to introduce the Chief Justice of the DIFC Courts and Head of the DIFC Dispute Resolution Authority, Dr. Michael Hwang, who will introduce tonight's keynote speaker. Chief Justice Michael Hwang is a graduate of Oxford University. His legal experience is vast and deep. He served as the head of litigation and arbitration for Allen and Gledhill, Singapore's largest law firm. He served as a judicial commissioner of the Supreme Court of Singapore. Michael was elected a member of the American Law Institute and was a commissioner of the United Nations Compensations Commission. He served as Deputy Chief Justice for the DIFC courts for 5 years and was appointed Chief Justice in 2010. In 2014, the Chief Justice was appointed the head of the Dispute Resolution Authority and head of the DIFC Arbitration Institute. In the same year, he was conferred an honorary degree of Doctor of Laws by the University of Sydney. With great pleasure, please allow me to introduce Chief Justice Michael Hwang. Thank you.
Good evening, ladies and gentlemen. Welcome to the third DIFC DRA Academy lecture of 2016. We are delighted to be joined this evening by Lady Justice Elizabeth Gloster, a judge of the Court of Appeal of England and Wales. Dame Elizabeth Gloster will give us an insight into the latest trends in global commercial litigation, posing the question, how digital are we really? It's well known that Dubai places great emphasis on IT in its daily transactions, both in the public as well as the private sector. And it's no coincidence that DIFC courts recently launched the GCC's first Smart Small Claims Tribunal, which provided parties in dispute, as well as the judge, access to the case from remote locations on smartphones and computers. So I think Lady Justice Gloster could not have picked a better city to deliver a talk on this very topical subject. And of course, speaking about topical, Lady Justice Gloster is well known in the UK for having presided over what was possibly the longest case ever in the commercial court. And she will, I think, share some of her experiences with the IT equipment and software that was used for that very famous case between the two Russian oligarchs. But before I hand over to tonight's guest, allow me to tell you a little bit about Dame Elizabeth Gloster's distinguished career. She was called to the bar in 1971 and became a bencher in 1992. And she was appointed QC in 1989, less than 20 years after she was first admitted. She then served as a judge of the Courts of Appeal of Jersey and Guernsey and as a recorder in the English courts until she was appointed to the Queen's Bench Division in 2005. And in 2010, she was appointed as the judge in charge of the Commercial Court, a title shared by some of our other present and past judges. And she was elevated to the Court of Appeal on the 9th of April, 2013. She is accompanied on this visit by her husband, Sir Oliver Popplewell, who is a retired High Court judge and famous in his own right. Now, unknown to them, these two people have been my heroes from the past for different reasons, which I will now explain to you. Lady Justice Gloster and I actually worked together on the same case, in the sense, many years ago, in the sense that we both had the same common client. The client was an Indonesian airline known as Garuda. Some of you may have heard of it. Some of you may have had the misfortune of flying on it. And I can't remember how many years ago it was, but they got into financial trouble. And in Indonesia, there is no insolvency, no Chapter 11 regime. But they were advised that if Chapter 11 type of remedies were granted by the courts of countries where Garuda had large offices, that would be taken into account in Indonesia when their case came up for disposition. So Dame Elizabeth then led the charge on behalf of Garuda in London and made an urgent application to the court in London for an approval of a scheme of composition. She worked round the clock and managed to persuade the judge to give her a very effective order, which was turned around in, I think, either 24 or 48 hours. We were waiting for that judgment in Singapore because I had to do the same thing in Singapore on behalf of Garuda. And I was, of course, assisted in this by receiving not only the judgment from the English court, but Lady Justice Gloster's submissions as well. And so that got me through getting a similar order from the Singapore court. Of course, we were just discussing it today as to what happened after that, and I had to fill in that despite our earnest and sincere protestations at the time that this scheme would fix everything, I think within 5 years, Garuda was back again for a second rehabilitation. But never mind, they're still flying. So Oliver and I have never met until today, but I've been very aware of his existence, apart from the fact that he is a very famous retired English judge, and apart from the fact that he's a prolific author, and if you go into any legal bookshop in London, you will see a number of his books. Sir Oliver actually, after he had had a full career as a judge, and of course having secured his first university education at Cambridge, then decided after retirement to go to Oxford and take another degree as a mature student for 3 years. And he subsequently written a book about his experiences, which I'm sure I will like to read one day. But the real reason why I remember Sir Oliver very well is because of my view that he saved the career of what I term to be England's greatest gift to the English language, Mr. Stephen Fry. I don't know how many of you have read Stephen Fry's autobiography, but those of you who have, or those of you who may not have, may be aware that Stephen Fry was rather a wild youth, and he got into serious trouble for basically peddling stolen credit cards, and was charged in a provincial town. It so happened that his parents knew Sir Oliver very well and brought this very famous barrister from London. Sir Oliver and I were not sure whether he was a silk by that time, but he was certainly famous, and did a plea in mitigation in this magistrate's court and managed to persuade the judge not to send Stephen Fry to jail. After that, of course, he completely reformed, went to Cambridge, got a scholarship, and the rest is history. So Sir Oliver is the person responsible for preserving and indeed launching the career of Stephen Fry, for those of us who have greatly enjoyed his contributions in various fields of entertainment. So, ladies and gentlemen, enough from me. We'll now welcome to the podium this evening's guest, Lady Justice Elizabeth Gloster.
Thank you very much, Chief Justice. Chief Justice, Deputy Chief Justice, judges, ladies and gentlemen, it's a great privilege and a pleasure to be invited by the Dubai International Financial Centre Courts and the DIFC Academy of Law to deliver this lecture in this great building. It has also been a great privilege and instructive for me to meet with the Director General of Legal Affairs Department and to meet him in his office this afternoon. However, and here are the two buts, I'm not sure that it's such a privilege or a pleasure to be told, and it may not be true, but to be told that I'm to be a guinea pig for the Academy of Law's first live streaming event. The second problem about this afternoon, and my speaking to you all, is that in a row somewhere near the back is my former pupil master. Can you imagine giving a speech in front of your former pupil master? I'm talking, of course, about Sir John Chadwick, who will you recognise by the fact that he's got 2 black eyes. No, I didn't give them to him. Anyway, my speech tonight has been entitled by me, Trends in Global Commercial Litigation, How Digital Are We Really? I'm not sure I'm going to stick to the title altogether, but however, here we go. I'll be interested to share views with you as to how litigation is conducted in this jurisdiction. I'm not just here to bang on with my own views and experiences. As the Lord Chief Justice of England, Lord Thomas, said in his lecture here in February, and I quote, "Strong and effective markets, businesses and commerce, which provide our prosperity and our economic development, must be grounded on a firm commitment to law and the rule of law. That is true of national markets and businesses as it is of transnational and international ones." The invitation which the DIFC courts has extended to me to deliver this talk provides a useful opportunity in our globalized marketplace to strengthen and develop the reciprocal ties between our 2 respective commercial courts. And may I emphasize that in this context, when I refer to the English commercial courts at any rate, I do so with a small c. In that phrase, I also include the Chancery Division in its role as deciders of, the Chancery judges in their role as deciders of financial and commercial disputes, and also the technology and construction courts, all of which sit in the Rolls Building, the new flagship of financial, commercial and property litigation in London. And understanding our reciprocal ties, our mutual common law heritage, and the respects in which we differ, not least because of the demands of different geographical regions in which we, the respective courts, operate, seems to me to be critical to our working as courts in the global marketplace. That is because our understanding of the way we work enables us to provide a better service for the international businesses and businessmen whom we both serve and who have recourse to our courts. It enables us to provide a speedier and more efficient dispute resolution service. We as lawyers or judges have no justification for our existence separate or distinct from the problems which litigants choose to bring to our courts to be decided. The elegant articulation of principle or precept by a judge, whether he be a district judge or a Supreme Court justice, and even though his learned remarks may populate the law reports or the voracious appetites of academics or textbook writers, have no freestanding validity or intrinsic worth of their own, beyond their ability to contribute to the resolution of the particular dispute before the courts, or to provide some sort of precedent for similar cases in the future. And, dare I say it, there may be, that point may sometimes be lost to some senior participants in the judicial process. I've had experience of this recently, where the Court of Appeal, of whom I was a member, allowed an appeal. I wrote a dissenting judgment on one small aspect. It was a case of illegality called Patel and Mirza. We refused permission to appeal. It involved only about £500,000 and costs. The Supreme Court granted permission to appeal and packed the bench with 9 Supreme Court justices. The outcome was clear, in my view, from the start. The appeal was never going to be, the appeal by the unsuccessful defendant before us in the Court of Appeal was never going to be allowed. The Supreme Court simply wanted the opportunity to address exciting, intellectually stimulating issues of illegality for yet the 3rd, or was it the 4th or the 5th time. I'm pleased to say that my dissenting judgment on a particular aspect, and I won't bore you with it, was magnificently upheld by 5 or perhaps 6 of the Supreme Court justices, and the other 4, was it 3, also upheld our outcome. And Lord Sumption also seemed to uphold my dissenting judgment, but seemingly thinking I decided something quite different from what the majority thought I decided. But that seems to me, and of course I was thrilled with the judgment, and it's going straight into Gough and Jones on restitution. The point is, for the party's sake, was there any utility really? Was there a service being provided to the hapless claimant who had to wait another year or so, or perhaps even more, for the resolution of what for him was no doubt important, but was fairly limited in value? My subject tonight, trends in global commercial litigation, starts with the trend of collaboration. And I would single out this trend as the increased appreciation of the need for cooperation and collaboration between international commercial courts. I confess that I certainly have felt caught up in the maelstrom or vortex of that trend in the last week. I've participated in a judicial insolvency network conference in Singapore, and attended by judges from various jurisdictions to discuss the way in which judicial cooperation in insolvency matters might be encouraged and facilitated. The conference, which rejoices in the acronym GIN, without the tonic, has drawn up draft guidelines for the promotion of practical intercourt cooperation, which the participating judges are looking to get approved by their respective jurisdictions. I've no doubt that cooperation in this respect would be gladly extended to this jurisdiction. Then I jetted on to Melbourne, where I was kindly invited by the Chief Justice of Victoria to speak at the Supreme Court and Melbourne University Commercial Law Conference on my views as to whether commercial litigation ticked the boxes. And now I believe it's Tuesday, and I believe I'm in Dubai. But what trend do I discern from all this? That commercial courts in our global village are indeed coming together to share practices and understandings as to how we, and I include a number of jurisdictions, the preeminent commercial courts and commercial lawyers can achieve better solutions for international businessmen whose trading interests and activities extend across numerous national and international borders. No man is an island, said John Donne, the poet, and that is as true of commercial courts as it is of man himself, and an appreciation that we operate in the context of a globalized marketplace with its pressures, demands, and deficiencies, and not in the isolation of our own perceived intellectual excellence, is an important lesson for all of us, particularly for the UK, in the uncertainty of our post-Brexit world, about which I shall make no comment. The second trend I would identify is the developing global appreciation of the need for and desirability of improved methods for the cross-border recognition and enforcement of commercial judgments. That is to say, the ability seamlessly to obtain the recognition and enforcement of judgments obtained in country A, in countries B, C, and D, where frequently the asset of the defendants may be located. And I must be very careful where I tread here, because I saw on the outside of the courts building, the DIFC courts building, that it is also the centre of the DIFC arbitration initiative. And I will therefore be as polite as I possibly can. The bedrock or principal reason for the popularity and success of arbitration as a means of commercial dispute resolution has traditionally been the so-called facility of the enforcement of arbitral awards under the New York Convention in the numerous countries who are parties to that convention. Although the apparent confidentiality of the arbitral process has also been put forward as a reason for arbitration's popularity, a dubious advantage, in my view, given the social media and revelation of many arbitration proceedings on social media. But parce, both your Chief Justice and your Deputy Chief Justice, Sir David Steele, and others of you who sit as commercial arbitrators, arbitration is not, in my view, and I'm speaking only personally, a satisfactory medium for the resolution of many types of disputes. For example, it cannot, other than by consent, which is rarely forthcoming, cater for the determination of multi-handed disputes. This defect notoriously gives rise to different tribunals deciding essentially the same issue, coming to different conclusions. Second, the arbitration is not an ideal method for the determination of allegations of fraud, misrepresentation, or misappropriation. Arbitrators are, in my experience, and again I'm speaking only personally, often very reluctant to make factual findings of fraud or similar types of misconduct. And witnesses are often protected by the cocoon of the privacy surrounding arbitration hearings. Witnesses often in arbitration have no fear that dishonest evidence will expose them to the glare of publicity or of contempt-type sanctions or freezing orders that a commercial court can impose. Indeed, freestanding tort-type allegations outside the contractual context can't even be arbitrated at all unless by consent, which again is rarely forthcoming. Thirdly, arbitration proceedings are subject, in my experience, to even more delays and frustrations than those which beset court proceedings. Arbitration proceedings can lead to excessive and disproportionate costs and expense, just as badly managed commercial litigation can. Many commentators write about the increased and over-lawyered approach to arbitrations, voluminous witness statements drafted by lawyers, and disproportionate and disclosure or discovery exercises, delays caused because of the non-availability of busy arbitrators or counsel, leading to fragmented hearings. And these problems lack, in many cases, the ability of a tough judicial type case manager. Increasingly, and this is the fourth defect, as I see it, of arbitration, there is a risk that the supervisory court of the arbitration, or the court which has to recognise and enforce the award, may be more willing than it has in the past to subject the awards to greater scrutiny and either set them aside or refuse to enforce them on New York Convention grounds, whether because of lack of jurisdiction or in the tribunal itself, or because the ever-widening public policy grounds that are often invoked to restrict enforcement or recognition. And of course, the recent well-published example of the risks inherent in the arbitral process is the decades-long UCOS arbitration, which I'm sure you will have all read about in the press, where the former shareholders in that Russian oil company originally obtained compensation orders in billions from an arbitral award made in a number of arbitrations by the Permanent Court of Arbitration in The Hague, in an arbitration constituted under ECT rules. However, the Russian state appealed, and as a result, the Hague District Court in April of this year, and remember the arbitration had been going for some 10 years, set aside the awards, making them probably unenforceable in most jurisdictions where assets were located, on the basis that the arbitral tribunal did not have jurisdiction. Interestingly, I thought, the Hague District Court did not need to decide other interesting issues raised, such as the competence of the arbitrators and issues of fraud. I'm told that one of the issues that arose in relation to the competence of the arbitrators was not only one of them's age, but also the issue as to whether the arbitral assistant had written too much of the judgment. And how have commercial courts and commercial jurisdictions responded to what has traditionally been perceived as the advantages of arbitration, namely enforcement under the New York Convention? Well, the trend that I see is an increased enthusiasm and strength of purpose amongst commercial jurisdictions to invoke the procedures for the regulation and enforcement of commercial judgments, which are contained in the Hague Convention on Choice of Court Agreements, which was originally signed in June 2005, but 2 years later had only been ratified by Mexico. Not much use there. But after a decade of languishing as an ineffective convention, the Hague Convention is now appearing on the horizon again. The EU ratified it in June 2015. As a result, it came into effect on the 1st of October 2015. And I was told in Melbourne that Australia is now giving active consideration to ratifying the convention, and that legislation is currently being prepared to put before Parliament. I'm also told that it's also under active consideration in other countries. The long-term aim of the convention is to create an international legal regime for choice of court agreements, similar to that established by the New York Convention in relation to arbitrations. The Hague Convention provides that an exclusive law agreement, choice of law agreement, will be enforced in every signatory state, that other signatory states must refrain from asserting jurisdiction in breach of the choice of court clause, and that where a judgment is obtained, by the chosen court, it will be subsequently enforced and recognized in other signatories to the convention. That will, in my view, if what is envisaged occurs, greatly improve the easy enforcement of commercial judgments. A number of commentators are suggesting that the potential for exponential and widespread adoption of and ratification of the Hague Convention will lead to the resurgence of commercial litigation as the preferred means of enforcing commercial obligations, offering as it can and should certainty, speed, and transparency of process, coupled with rigorous case management by commercial judges who are, of course, subject to appeal procedures. In a way, the implementation in 2009, as between the DFICC and England and Wales, of a memorandum of understanding relating to the recognition and enforcement of judgments between our two jurisdictions, was a mini reflection on the goals which the Hague Conference is trying to achieve. How satisfying that we two countries were early travellers down that road. And I learn from Mark Beer, your registrar, that there have been more MOUs, and indeed that he and the Chief Justice are travelling to Shanghai very soon, hopefully to sign a MOU with the PRC. Of course, the extent to which foreign judgments will be recognised and enforced is always a delicate and sometimes ticklish issue. Problems of comity can arise particularly, as we know, in the insolvency context, which the Hague Convention doesn't address, it excludes it. An interesting issue in this area, if not capable yet of being characterised as a trend, but which I'm sure is due for reconsideration at the highest level, both in the UK and in other jurisdictions, is the extent to which a decision in a foreign insolvency proceeding can discharge or render invalid a contract or the provisions of a contract whose proper law is subject to the laws of the home state. Let me give you one recent example which is interesting and has huge potential for the enforcement and recognition of schemes of arrangement of the type which the Chief Justice and I promoted all those years ago. I'm talking about ipso facto clauses, as they are called. That is to say, clauses that give one party, usually referred to as the non-defaulting party, the right to terminate a contract if the other party enters into an insolvency procedure or becomes insolvent. These clauses have been held to be valid as not breaching the anti-deprivation rule, that's to say, the rule which protects the interests of all creditors by preventing parties upon the commencement of an insolvency from withdrawing assets from the insolvent estate. An ipso facto clause will only be held to be valid where the claim represents an unintentional or inevitable, will only be held to be invalid, where the clause represents an intentional or inevitable evasion of the principle that the debtor's property is part of the insolvent's estate and should be distributed pari passu. And for that, that was decided by the UK Supreme Court in Belmont Park in 2011. What happens, however, when another jurisdiction, which is the court conducting the liquidation or insolvency, takes a strict view of such ipso facto clauses determining a contract or giving a right to determine a contract in the event of insolvency? The US, for example, takes a much stricter view about the validity of such clauses than the UK does. The recent case at first instance in the UK of Fibrosa against Pan Ocean was a decision of first instance where a Korean shipowner entered into a long-term contract of enfreightment with charterers. The contract was governed by English law and provided for London arbitration. A clause of the contract provided for termination with immediate effect on notice in writing for default, which included insolvency. The Korean shipowner became insolvent, and an insolvency process of rehabilitation was started in Korea, which was recognized by the English courts as the foreign main proceedings for the purposes of the UK cross-border insolvency regulations, which give effect to the UNCITRAL model law. The charterer, who was out of the money, wanted to terminate the contract because the freight rate it was being charged was in excess of market rights. The insolvent Korean company, in the money, for obvious reasons, wanted to keep the contract alive in the liquidation. Its insolvency administrator claimed in English proceedings that the termination clause was unenforceable as a matter of Korean law, although he accepted that it was valid under English law. The administrator sought an injunction under the regulations preventing the solvent charterer from serving a notice terminating the contract. The administrator claimed that the court could do so under a provision of the regulations enabling the court to grant any appropriate relief. The first instance Chancery Judge Morgan J. held that it was not appropriate to grant relief under the regulations, even if Korean law of the insolvency regarded the termination clause as invalid. He said that since the contract was decided by English law, or it was governed by English law, and under English law the clause was valid, as not falling foul of the anti-deprivation rule, it was not appropriate to alter the substantive rights of the parties under English law. In doing so, he was implicitly, albeit not expressly, applying the old established common law authority of Anthony Gibbs against La Société Industrielle et Commerciale des Métaux, an 1890 decision, which famously held that in relation to foreign insolvency proceedings, discharge or termination of a contract or liability governed by English law was governed by English law, whatever view the foreign insolvency law took. Gibbs has been strongly criticised by academic writers as belonging to an age of Anglo-centric behaviour which should be consigned to history, although it has been acknowledged as good law by both the Privy Council and the House of Lords, albeit some time ago. It remains binding potentially up to the Court of Appeal level. Some other common law jurisdictions still follow it, but others have declined to do so, and in particular, a different result from that in the Korean case has been decided only in September by Ramesh, a judicial commissioner in the court in Singapore, in relation to the effect of schemes of arrangement on foreign law, although Hong Kong may or may not be taking a different view. Now, this issue is going to come back. It has significant impacts for the type of schemes of arrangement which we were dealing with in Garuda. So watch this space. The third trend which I would like to refer to is the recognition by commercial courts of the need to design specific fit-for-purpose tools to improve the resolution of specific types of commercial disputes. I give you one example of the way in which such tools have been implemented in England. As I'm sure you know, and as I'm sure this jurisdiction too, we have historically had market disputes often related to standard financial instruments and loan documentation dealt with in our commercial courts. Since October 2015, there has been a new initiative in the English courts, a joint venture called the Specialist Financial List between the Chancery Division and the Commercial Court. This has been set up in accordance with a practice direction, and individual judges from both the Commercial Court and the Chancery Division with specialist expertise and experience of financial markets are assigned to deal with particular cases that go into the financial list. The objective is to ensure that cases that raise issues of general importance to the financial markets are judged by judges with highly specialist expertise, so as to provide a fast, efficient, and high-quality dispute resolution services of claims related to finance, banking, and the markets. The financial list includes provision for an innovative test case procedure, the aim of which will be to facilitate the resolution of market issues on which there is no previous authoritative statement, even possibly at a time when, at least to a certain extent, the issues are hypothetical or may only arise in the future. There have been a number of decisions already in the financial list. Interestingly, one case where the Chancellor ordered the transfer from the normal Chancery list into the financial list of a case involving claims made by a customer against treatment of his account by the bank RBS, alleging mis-selling of interest rate swaps and the alleged improper conduct of RBS in relation to the fixing of LIBOR, issues which one might regard as very specific and fact-heavy and maybe not suitable to a specific financial list, but one particularly amenable for a Chancery judge with extensive experience of deciding fact-heavy cases. But the financial list is an example of commercial litigation process ticking the boxes, adopting new procedures in order to provide a better service. Whether it will in fact improve the service and whether one really needs a specialist list carved out of existing Chancery and commercial judges, only time will tell. And finally, the fourth trend that I'd like to share my views with you about has been the widespread adoption of digital and electronic working as an integral and essential part of commercial litigation. Certainly in the UK rolls building courts, digital working is employed not only now in the filing of claims and applications and the uploading of relevant documents and the court files, which are now electronically available to the relevant parties 24/7, but also electronic working by the court administrative staff in their case management and case progressions. Now, I know because Mark Beer, your registrar, was extremely helpful in contributing information about appropriate systems. I know that you've got an all singing, all dancing system here. But what is interesting is that these systems are developing extremely fast. For example, the conduct of disclosure and discovery, as I think you may still call it, is materially assisted by sophisticated systems such as TAR, technology-assisted reviews, by predictive coding, and by programs which can deduplicate repetitive emails. In particular, some of these programs are intelligent enough to learn from sample relevance testing of documents to identify documents in the universe which a party holds, which fall within the scope of the relevant disclosure order. And when it comes to the trial itself, at least in high-value commercial claims that are document-heavy, the probability is that in the UK commercial courts, the trial will be conducted with simultaneous live-time transcripts appearing on individual screens for the judge and the lawyers, and that there will also be EPE, or electronic presentation of evidence, so that everyone has digital access 24/7 to the documents, which are bundled in an easily formatted way and presented on the cloud, or alternatively on a USB stick. They replicate the way in which the hard copy bundles would have been marshalled and provided. In the case which the Chief Justice referred to, the Berezovsky and Abramovich case, which I decided before going up to the Court of Appeal, the documentation and case materials were absolutely huge. This was actually rather surprising because, in essence, the case that Mr. Berezovsky was putting forward was that Mr. Abramovich had agreed orally to give Mr. Berezovsky a 50% interest in various oil companies and aluminium companies, and had orally made threats of intimidation and physical threats against Mr. Berezovsky. So somewhat surprising that there was this universe of documents. I just have to tell you of the numbers of documents. There were 20 different sets of bundles designated from A to T, with each set in itself often comprising further subsets of bundles and numerous numbered individual files. For example, there were 9 subsets of what were euphemistically referred to as selected disclosure bundles, of which the principal subset of chronological documents itself ran to what in hard copy was 99 lever arch files. There were 13 files of witness statements, 36 files of expert evidence addressing Russian history and Russian law, most of which was irrelevant and inadmissible. Well, for someone like me, who is absolutely hopeless at hard copy paper management, the EPE system was a godsend. I couldn't have managed without it, because counsel, despite the nature of the allegations, as you may imagine, made copious reference to the various documents. But, and again, this is the big but about the use of these electronic tools in commercial litigation. It seems to me that there is a problem with our reliance on these electronic tools. There is a problem that we let them do the work rather than applying our minds. First, my experience, and I see this in the Court of Appeal as well, is that counsel and solicitors do not, at the disclosure discovery stage, sufficiently turn their minds to considering whether there should be appropriate restrictions to the disclosure, to the scope of disclosure which the court orders, or to question whether the vast exercise to be carried out with the assistance of the all-singing, all-dancing electronic tools should indeed be carried out at all. Council, in my experience, do not sufficiently consider whether the disclosure order is excessive. They're all too concerned with working out how the electronic tools should play their part. They do not consider whether standard disclosure, which is the default option, is appropriate. They don't say, well, why don't we just have disclosure restricted to 3 or 4 key issues? And also, it's my view, or it's tentatively my view, that often the trial judge is not sufficiently proactive in banging the parties' heads together and saying, well, it's all very well you coming up with these marvellous programs for electronic disclosure, TAR, deduping, as it's called. I want to know why you need all these documents. This case revolves around the construction of a few provisions in a contract. Surely factual matrix can't require analysis of all these documents. And it seems to me that we judges, trial judges, have a real obligation to consider whether this huge expense which electronic disclosure, e-disclosure, involves is justified and proportionate, and has to test the parties' legal representatives as to whether it is necessary. The issue is this: lay clients have no control over the process. Electronic assisted disclosure is a tool. It is not a profit centre. And I've certainly heard complaints from litigants that they are concerned as to the amount of money they're finding they're having to spend on the disclosure process. So what is needed is human decisions by judges or advocates to ensure that the scope of disclosure is restricted and proportionate. Secondly, my but about electronic tools is that there are limits to the willingness of both counsel and witnesses to use electronically presented documents. Although I managed to conduct a paperless trial in the Berezovsky case, counsel, and there were a clutch of extremely distinguished counsel appearing at vast expense, appeared to be working off hard copies throughout the trial, not just for the cross-examination of witnesses, but also for following the evidence and for submissions. Every morning, trolleys piled high with ring binders would be carted into court by some luckless junior clerk out of a Dickens novel. And at the end of the day, sure enough, the trolleys would be carted out again by the same poor clerk. Do counsel, and in particular leading counsel, need the comfort blanket of hard copies and physical paper yellow stickers? Or are they just not able to cope with the new technology, which I find surprising? Or are they addicted to remembering page numbers, a skill many barristers seem to have? I don't know, but I do find the addiction to hard copy bundles surprising. But having said that, funnily enough, many of the witnesses in a number of commercial trials I've done, and in particular the Berezovsky trial, the witnesses themselves preferred to work off hard copies, even though they would be offered iPads or computers with the electronically presented documents in front of them. Why was that? I suspect because many of them were very intelligent and astute, and they knew jolly well that if they had in front of them the bundle of witnesses for Mr. X or Mr. Y, they'd be in a position to remind themselves of the document or email that appeared at the end of the series of documents, or flick back to the beginning when they were asked a particularly different question. And each witness, or pretty well every witness, was asked, well, which would you prefer? And they'd all be sitting in the back of the court working on their phones or their iPads. But when it came to actually giving evidence, oh, no, 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 they much rather have the hard copy documents. That gave them time to think and articulate their answers. But I think we should encourage, both as advocates and as judges, a change in the mindset. And in particular, I'm speaking here to you younger lawyers. I mean, you're incredibly efficient on digital tools. Surely you're going to be able to cross-examine off electronic documents. But again, I'd be very interested to hear your views as to whether it's feasible or not. And finally, this lecture would not be complete without a heartfelt cry from this particular Court of Appeal judge. Once the trial process is completed, certainly in the English Court of Appeal, the parties don't seem to think it's necessary to ask Court of Appeal judges whether they would like to work off electronic bundles. There's nothing in the Court of Appeal rules that requires parties to offer electronic copies of bundles. And when I ask, which I frequently do when I'm dealing with a document-heavy appeal, whether I could possibly have, or my colleagues and I could possibly have, an electronic copy of the bundles, I'm looked at by counsel as though I'm Oliver Twist asking for another plate of soup. And I'm frequently tempted to say that the cost of the electronic transformation of the hard copy files into digitally available ones would be a fraction of the daily cost, the daily fees attributable to all the counsel present in court. But of course, I'm far too courteous or polite ever to mention anything quite so vulgar. So that is my perspective of current trends in commercial litigation, or at least a few of them. I shall be very interested to hear your views and share your experiences from your perspective of conducting commercial litigation in the DFIC courts. Thank you very much.
We have about 15 minutes for Q&A, and Clifford has a microphone, so he'll run the show. Thank you.
There was a recent conference chaired by Sir Richard H., the former commercial judge of Leonard launched into a pretty idiotic attack on the quality of the service that the commercial court in London could furnish, and drew invidious comparisons between the Rolls-Royce and the commercial court and international commercial court in Singapore. Some might have regarded the attack as slightly unattractive, but was it justified?
Since this is being live streamed and maybe be going viral on YouTube in the light of your question, I shall be very careful and moderate in my response. The truth is, and with respect to Sir Bernard, his comments were ill-informed. He sits occasionally in the commercial court, but the reality is that he hasn't been a judge there for some years. He was only there for a brief period of time, and in certainly the last year or so, the electronic presentation of documents, the electronic filing of documents, and the electronic working provided for not only the commercial judges, but all the judges, has changed out of all recognition. We are no longer using what's called a DOM1 computer, a government restricted program we are now on something called e-judiciary, which is simply wonderful. I can use it on the bus, I can use it in a hotel bedroom, wherever I go, anywhere through the world. Things have changed immeasurably, and again, with respect to him, or with no respect to him, I would say that particularly from his perspective, that was simply a wrong comment. And probably, David, when you left, you didn't have, if you use it at all, a lot of technological assistance. But now, I mean, it's simply wonderful, and it works. And if we were allowed to engage in debate in the press, which as judges we're not, I would have made a comment to that effect. Yes, at the back. Are you a barrister or a judge?
Neither, it's Mark.
Oh, Mark. Sorry, I couldn't see. I obviously need a new pair of glasses.
Thank you. Wonderful presentation. And those areas, particularly collaboration and technology, really ring true for us here. But the IT advisor to the Lord Chief Justice in the United Kingdom has spoken of doing away with judges for small claims, automating small claims, and having computerized holographic judges in the future instead of real judges, human beings. Are you petrified of his predictions for the future of the UK court system?
No, and I'm not sure. You're talking about Professor Richard Susskind, I assume. And I don't think his prediction goes quite that far. Certainly Lord Justice Michael Briggs, in his final report, and indeed his interim report on civil procedure in the courts, has suggested an online court, which is very different from this type of holograph algorithm court that you were suggesting or putting to me. The online courts will deal with small claims. At the moment it's suggested of £25,000 or under. The procedures will involve, certainly at the first instance, parties being assisted in filing their claims online. But the notion which Professor Susskind has raised, that it'll be an algorithm or some sort of computer or drone deciding actual cases, certainly isn't envisaged at the moment by the online courts, which will involve a triage process, and if at the end of the day there remains a dispute to be resolved, which can't be resolved by a non-judicial officer, then the issue in question will be decided by an actual real-life, real-time judge, although not necessarily involving any court appearance by any of the parties. But Richard Suskind's great. He's got great ideas for the future. I'm sure he's lectured here. In fact, I'm sure he told me he's lectured here in Dubai to businesses. I don't know whether he's lectured in these courts. And certainly judges and real people and real lawyers have got to remain, certainly for the type of commercial disputes that we're talking about. There's no way in which an algebraic formula could resolve most of the cases that we deal with. But there is a need, as Michael Briggs has recommended, for much more online resolution of claims and advice being given to litigants as to how to present things by an online process in the way that one buys a driving license or takes out an insurance policy. I would love to hear the views of some of you who practice here as to what use you make of electronic documentation in the trial process.
Thank you, Roger. The question here is about the connection that is already available between commercial courts and family courts in the UK. And do you see that the digital wave that coming in would help the commercial and family courts to be connected in terms at least of enforcement of orders and among the rest of the world is that something that we should see coming in the future? Thank you.
Well, when you say the connection between family courts and commercial courts, I'm not sure I quite understand what you mean. Can you explain a bit further, please?
So we have a family court that has some elements in assets, for instance, between parties, where there are some businesses, with the enforcement of orders between these courts can ever happen, and especially with the digital, like what we're talking about now, with the e-judicial possibilities, would that ever be a possibility?
I would have thought so. Certainly the Hague Convention on Choice of Courts does not include family law. It excludes family law. But so far as e-working is concerned, I don't have any experience of family work at first instance. My guess would be that they don't use a lot of presentation electronically of documentation. I certainly think in the heavy financial cases, it would be a very good thing if they did. And but you tell me, do you practice at the family bar? And here are the documents all electronically presented?
Not yet. I have to say that we are not that super e-judicial yet, and that applies to the courts, the courts in the UAE. So we have a system that is available for us as lawyers to keep track of our cases, but the court itself would not yet accept anything that is on a digitally as a submission. So yes, until now we are very much hard copies, paper, work submissions, of course.
Well, I would have thought it would be a very good thing, certainly in the UK and anywhere really, that the commercial aspects of family law should be presented in the same way that any financial dispute is presented, in a modern, up-to-date way, which facilitates speedy resolution in what is often a very unpleasant and emotional situation. Married people fighting about how much money they should each have.
Thank you very much for your response.
Would any of the commercial barristers share their experience on using electronic documents in commercial cases?
Just before that.
Yeah.
Yeah. But I just wanted to ask about the Hague Convention. Do you think it's outdated? Because this day and age, with the DIFC, you can notify electronically and that sort of. I think the Hague Convention is very outdated. What are countries going to do? What's your thought?
Well, my thought is that it would be very desirable if notification could be done electronically. I mean, as long as it can be verified or validated in the sense that there is no security issue, I would agree with you.
And the second, do you see any of the countries taking proactive approaches to resolving or advancing that kind of, maybe notifications as well, but there's a lot of other things as well.
I think my experience, and it's mainly of common law jurisdictions, is that we are all moving forward to a much greater use and deployment of electronic digital working. But we've still got a long way to go, whatever people say about it. Yeah.
Since you asked for, I'm not sure I still qualify as young, but somebody's experience of working electronically, I would say three things. First, when it works very well.
Yeah.
But if there's a glitch, that's when you start to appreciate the old hard copies. But the second and third are probably more relevant. I speak about the second probably as a serial offender who has graduated from abusing the copy and paste function when preparing skeleton arguments to, well, the bundle will fit on a USB stick. And that applies both to authorities and to documents. I think in the old days when you did have to think, well, what is a judge going to make if we deliver 12 boxes to her? You think a lot less about that when you're saying, well, I'm going to deliver a USB stick.
Yes.
And I think that's what resonated with me about your presentation. And the second thing that resonates, it is great when you have all of the high technology in one court and all the papers presented and prepared in one way. But then, as you say, in the modern world, particularly in my field, which is fraud and asset recovery, it's pretty much inevitable you're going to go to other jurisdictions.
Yeah.
And for my way of working, it would be ideal if the court started to collaborate with a consistent means of electronic presentation. Not least that then it would be a lot easier, I think, to have a central data room, for want of a better phrase, of papers in the various jurisdictions. So if you need to look at proceedings in a freezing order in the Cayman Islands, or proceedings in a disclosure order in Bermuda, or a proceeding in London, and vice versa, the judge in Cayman needs to see the ruling in London. It's all up there. It'll be a lot cheaper, a lot easier, a lot faster.
But there are programs that provide that at the moment. I mean, I entirely agree with you, but the sort of program that I had in Berezovsky, provided you're given access to it, a judge in Bermuda, a judge wherever, could likewise have accessed from Bermuda or from Cayman the documents that were on the cloud. And you can upload verified copies of orders, and on the whole, with rare exceptions, people don't forge orders. I mean, they do sometimes, but and I agree with you. And the problem is that if you get fixated on the court itself providing a service for the litigant, that service will be out of date pretty quickly and won't necessarily interface with the digital system that's being used in another country. And that is why I'm in favour, again speaking personally, of certainly the court-provided service, even if EPE should be able to speak to some of the commercial products which are going to be developing very quickly and are likely to be much more sophisticated. Well, I'm happy to answer any more questions at the reception, if that's what we're all going to now.
Thank you, Lady Justice Gloster, for those highly insightful and relevant comments. And now Mark Beer, our DIFC Courts Registrar, have a few closing remarks. Thank you.
Goodness, I'd forgotten I was meant to say something. And all I wanted to say was thank you very much indeed. It's a fabulous, what I'm delighted about is our courts share so much in common. The first memorandum that the United Kingdom courts had ever signed, memorandum of guidance on enforcement with any other court in the world, was with the little old DIFC courts. And the spirit of collaboration was strong then, and it's ever stronger now, with a panel being formed of Chief Justices of commercial courts from all around the world to be first meeting in London. And I know, Lady Justice Gloster, you've been critical to that. So thank you very much for your presentation. I'd like to ask Chief Justice Michael Hwang to come up with yourself, Lady Justice Gloster, to present a trophy.
Right. Is there a photographer? Yes, there is.
There.
very much indeed. I've been criticised by the Chief Justice, he didn't actually use critical words, by taking up my lecture notes in hard copy on a long yellow leaf and not on my iPad. Of course, had I but well enough in time, I would have dictated it onto my computer. Thank you very much. That's wonderful.
And that draws a close to this evening. Enjoy it very much. We hope to see you at the reception tomorrow evening for the legal community, where you'll get the chance to meet with the judges of the DIFC courts and Lady Justice Gloster and Sir Oliver Popplewell. And until then, have a wonderful day tomorrow. Thank you.